I'm Dave Mullins. I'm a podiatric surgeon and healthcare attorney in Northern California. And as you know from the previous episodes, I'm also the author of How to Win Medicare Appeals, published by the American Bar Association. This is episode number 7 of the podcast, and the podcast is based on the book. Let's get started. What kind of administrative law judge hearing, should you always request? Well, Medicare wants you to do your hearing by telephone, but you don't want to do it by telephone. You want a live video hearing. Medicare calls this a video teleconference or VTC hearing. Why do you want a VTC hearing? Why not do it by telephone? Because you need to know in real time if the ALJ is paying attention to what you're saying or what your expert witness is saying or what the patient sitting next to you is saying. You need to know in real time if something is happening in that remote administrative law judge hearing room that is distracting the attention of the judge. Because if the judge isn't listening to what you're saying, you may as well not be saying it. Who has to approve your request for a video teleconference ALJ hearing? The administrative law judge assigned to your appeal has to approve that request. And you're going to have to submit a good cause reason or good cause statement in writing in order to get that approval. What are good cause reasons for a video teleconference ALJ hearing? Well, I think you could say something like this. Your Honor, the Medicare patient will be present at the hearing to show you the medical problem on their arm or on their leg and to be able to answer your questions regarding the problem and the treatment of the problem. Or, Your Honor, the clinical photograph submitted to the qualified independent contractor for the second level reconsideration appeal will be a focus of our presentation at the hearing. We need to know that we're both looking at the same portion of the same photograph at the same time as we are explaining what that photograph means in terms of the care of this patient. Or, Your Honor, the patient's imaging study submitted to the QIC will be a focus of our presentation at the hearing, and then the same type of explanation as you would use for clinical photographs. But it should be something that you present in a common sense fashion. Nothing tricky, just something that anybody would understand as a reasonable basis for the request to have a video teleconference hearing instead of a phone hearing. Why should you always have the patient sitting next to you at the VTC ALJ hearing? Having the patient sitting next to you at the hearing converts the hearing from a dispute over a pile of documents to a hearing regarding the medical needs of the person sitting next to you. The difference in dynamic between those two couldn't be any greater. Does the letter portion of the letter brief say what you want it to say? You have to have someone with no medical education read your letter and then tell you what the letter says. It's not good enough if they read the letter and say, gee, that's a great letter. They have to tell you what the letter says. If that person gets what you were trying to say, the ALJ is going to get it as well. But if that person doesn't get what you were trying to say, chances are the ALJ isn't going to get it either. Why does the ALJ have to understand the letter portion of your letter brief the first time she reads it? She doesn't have time to read it more than once. So it has to make sense the very first time. Stepping back, how does the administrative law judge appeals process actually work in the ALJ's office? Each Medicare administrative law judge usually has 2 attorney advisors and either a paralegal or a legal secretary. One of those 2 attorney advisors is going to get that big cardboard boat with all of the paper copies of all of the documents in your appeal. And all those paper documents in that big cardboard boat is referred to as a claim packet. And the attorney advisor is going to go through those documents and then prepare a memo for the administrative law judge. The last paragraph in the memo is going to say something like, Your Honor, I think you should pay this claim. Or, Your Honor, I think you should sustain the denial. You want to use shocking pink paper for the letter portion of your letter brief in order to get the attention of that attorney advisor. So the attorney advisor will look in that big claim packet, will look in that big cardboard boat, see those pink pages and wonder, what is that? And as a result, take out your letter brief first and read it first before the attorney advisor reads anything else. This isn't my idea. This was the idea of Bob Soltis, a retired administrative law judge. And his idea to print the letter portion of the letter brief on shocking pink paper isn't a good idea. It's a great idea. Never print the letter portion of your letter brief on white paper. Do it on shocking pink paper to get the attention of the attorney advisor. Why will the attorney advisor read your letter brief first? Well, we've already said that. The attorney advisor is going to wonder, what is that pink document? And it bears repeating twice, even if I got ahead of myself. Is going to look at that pink document and going to read it first. Why do you want the attorney advisor to read your letter brief first? Whoever speaks first before a neutral third party has a huge advantage in framing the dispute for that neutral third party. And you want the attorney advisor's first impression to be based on your letter brief. In other words, you want to be able to frame the issue for the attorney advisor before the attorney advisor reads anything else about your appeal. That's it for today. I'll see you next week.